Hi friends, I'm Chelsea Grayson coming to you once again from the Office of the CEO. This is my show where I can help you be more successful in your current career, and I can also help you successfully transition to a new career. So today is another episode in my continuing series on how do you understand legal agreements, or how do you make sure that the legal agreement that is supposed to memorialize your deal memorialized it accurately, so that the deal that you thought you were making as a business person has been captured and represented perfectly and accurately by the lawyers that drafted the deal documents. Today's going to be another quick hit. I want to continue to take you through some typical terms, defined terms that are used in legal agreements, so that you can understand how incredibly important it is when it relates back to the actual deal. So today's term that I wanted to discuss is the concept of knowledge, otherwise known as the knowledge qualifier. You're going to see the knowledge qualifier mostly in representations and warranties. And if you remember, representations and warranties are those risk shifting mechanisms. They're statements of fact as to the current status of a particular party to the agreement, that if they are wrong, the other party can sue for a breach of agreement, otherwise known as a breach of a representation and warranty. These are usually made if it's a merger or an acquisition. The bulk of the representations are made by the target or the seller in the transaction. If we're talking about a different sort of business arrangement, a strategic alliance, a collaboration, a joint venture, what have you, then both parties generally make the exact same reps and warranties to each other. So again, these are things as simple as my company was formed properly, and we continue to exist in compliance with the laws of the state in which we were formed. It can be more complicated. My company is in complete compliance with all environmental laws that apply to it. It can be Schedule 7.2 lists out all of the litigation that my company is involved in, and there is no other litigation to speak of. Those are representations and warranties. So remember, what we've also talked about is that the entity that's making the representation and warranty frequently has to add a qualifier to make that rep true. And the other party to the agreement doesn't always have to accept whatever that qualifier is. They might sometimes want to negotiate back and say, no, I need a straight representation and warranty, and I don't want anything to qualify this rep and warranty. And that's definitely a part of the negotiations. But one of the qualifiers that the person making the rep and warranty sometimes chooses to add is a knowledge qualifier. So instead of just giving a straight rep, we are in compliance with all environmental laws and regulations, you can say, to my knowledge, right? We are in compliance with all environmental laws and regulations. Now, what does knowledge mean, and what are the different ways that you can use knowledge? So if it's just to my knowledge, lowercase k, nobody really knows. Is that to whose knowledge is that? Is that the CEO of the company that's making the rep? Is it other parties in the company that helped form the company if they've been around for a long time? Is it the lawyer's knowledge that's drafting the document? Nobody really knows. So you want to be very specific. So here are some permutations of the so-called knowledge qualifier. So you can say, to the best of seller's knowledge, right? And that's a relatively high standard. So that's to the best of my knowledge, but that doesn't mean that I've done any looking around or kicking the tires as the party making the representation. It's just, hey, these are the things I know, and to the best of my knowledge, this representation is true. Buyer might not always want that representation because that's a standard, but it's not necessarily the golden standard. What about to the best of my knowledge after having performed diligence, or to the best of my knowledge after a diligent investigation? Now you're really putting me to it, because it requires me to go out there, kick the tires on my company, investigate what the laws and regulations are. Am I really in compliance, or after taking a deep look with my lawyer, we've figured out, we violated this ordinance, or we needed that permit, we're leaking something onto the neighbor next to us, whatever it is, right? So that's actually a much better standard if you're on the buy side to require of the seller. So to the best of seller's knowledge after a diligent investigation. Okay, it's obviously a lot more dangerous for the seller to make that. Another permutation is to the actual knowledge of seller, right? So again, that's probably less than best. And it's probably the lowest standard you can get from a seller, right, on the knowledge qualifier. So to the actual knowledge. So if I don't actually know something, even if other folks know it, even if it's pretty obvious, even if the authorities know it, if they haven't yet sent me a notice that I'm not in compliance with the environmental law or regulation, I haven't actually received that notice, so I have no actual knowledge that there's been a violation. Hey, that I can safely make that rep, and you cannot sue me later on if all of a sudden an authority post-closing, for example, finally sends that notice of a violation. You can't come back at me and claim breach of rep and collect damages for me for breach of a contract. So let me get back to something I alluded to at the top of this discussion, which is whose knowledge, right? So generally speaking, parties to an agreement are going to be corporate organizations, whether an LLC or a corporation or what have you. When it's an individual, it's pretty obvious. If two individuals are entering into agreement and they're both making reps and warranties, then they're making those individually. So when you say to the best of my knowledge, you're meaning Chelsea Grayson. But if it's an organization that's entering into the agreement, whose knowledge are we talking about? Again, it could be the CEO, it could be outside counsel, it could be a bunch of folks at the organization. So you need to make sure, depending on which side of this you're on, that you make it very clear whose knowledge we're talking about. We're talking about the CEO and that's it. We're talking about the entire C-suite. We're talking about the CEO and the board. What if we're talking about specifically named people not in positions, right? What if we're talking about, okay, it's to the knowledge of every single person in upper management, right? So that's sort of the last thing that I wanted to admonish you guys about, that you can have a perfectly good knowledge qualifier in a document, and when push comes to shove, nobody really knows whose knowledge we're talking about. And depending on which side you're on, you may or may not want that quote unquote knowledge to have been attributed all the way down through the organization. Because as I think we all know, sometimes there are things that are known or that people are aware of way down towards the junior levels of an organization, because those are the folks in the trenches every single day. They may have received something that they haven't passed up the food chain yet, or they're just seeing certain things, right? Things that haven't yet trickled up to the awareness or the knowledge of the folks that run the company, that are doing the deal, that are in these negotiations. So unless you want your organization to be attributed with what's going on in places that you may or may not have probed yet within the company down the food chain, then you want to be very specific about whose knowledge we're talking about when we say to the knowledge of. So that's my episode for today. I'll come back next week and continue this discussion of how to break down a legal agreement to make sure that you understand all of the terms and provisions so that you can best weaponize it in your deals. Please make sure and subscribe to my YouTube channel so you don't miss future episodes. I'll see you next time from the Office of the CEO.